Good evening or good morning to those connecting from different time zones to join us for this very timely webinar. This is the fifth one in our series discussing accountability for crimes committed in Ukraine. And today the situation is different than many months ago when we started with this series. The latest developments in Ukraine have resulted in the opening of the investigation by the Office of the Prosecutor of the ICC, and several national law enforcement agencies have also announced opening of the investigation based on the principle of universal jurisdiction. Today we will discuss what it means for victims in a conflict in its ninth year and what avenues for obtaining justice victims can seek. I'm very happy that for this important topic, we're joined by a panel of esteemed speakers in the field of international criminal justice, namely Paolina Massidda, Principal Counsel of the Independent Office of Public Counsel for Victims at the ICC, Dmytro Suprun, Counsel of the Independent Office of Public Counsel for Victims at the ICC as well, and Neistat, a Legal Director of the Docket initiative at the Clooney Foundation for Justice. Each speaker is given 10 minutes for an intervention, which will be followed by a Q&A. I also invite the audience to leave questions anytime during the three interventions in the Q&A box, and we will proceed with those questions in the Q&A session. Please specify also to whom is your question addressed. I think without further ado, we can proceed with our first speaker to introduce us to the extent of the victimization in the situation in Ukraine. Paolina, the floor is yours, please.
Thank you very much. Good afternoon, good morning, good evening, depending on where you are. First of all, thank you very much to the Platform for Peace and Humanity for this timely webinar and for the invitation. As just said, I will limit my intervention to few words about what victims are suffering at the moment and why justice is important for them. Since 24 February 2022, Ukrainian cities are under attack. Civilians see explosions and death firsthand and experience immediate disruption to basic resources like electricity, food, and water, and problems with reliable communication with loved ones. The Russian Federation's military offensive against Ukraine has triggered one of the fastest growing refugee emergency in history and the largest since World War II. Across Ukraine, critical infrastructures has been damaged or destroyed, causing outages of electricity, heating, and water in some areas, while some services such as internet connectivities, medical care, and public transport have been disrupted. As a result, many people find themselves with no resources or information on where to find safety and accommodation and are unable to meet basic needs, including food, water, and medicines. Given the lack of safe humanitarian access, the delivery of life-saving aid is difficult in many areas of the country. In accordance with the latest United Nations reports, as of 24th of May, over 6 million individuals from Ukraine have fled abroad. 7.7 million people have been internally displaced, and another 8 million are on great urgent need of humanitarian assistance and protection. Refugees have mostly fled in neighboring countries: Poland, Hungary, the Republic of Moldova, Romania, Slovakia, and other countries in the region. These countries have demonstrated extraordinary solidarity, providing immediate assistance to people arriving, but the scale of the displacement is putting considerable pressure on available services and on hosting communities. Of the refugee population, some 2.1 million as of 20th of May have continued onward to other European countries. 90% of refugees are women and children. Children are specifically vulnerable. Imagine the terror of a child faces in a dark basement, watching the faces of her parents, praying that the next missile will not hit their building. I found a reflection shared by a mother on Instagram story a few days ago. I quote, "Paolina came to our bedroom awakened by the sound of explosions. I didn't know and still don't know what to tell her. Her eyes today are full of fear and terror, eyes of all of us." Paolina is 7 years old. Alina, a 15-year-old who fled Ukraine, interviewed by UNICEF, said, "I never imagined I would experience war. Before the war, I had a lot of friends. We used to go out, to play, to do homework together, to go to each other's house, listen to music, just have fun. The atmosphere was calm and peaceful. Everything was perfect. My biggest problem back then had to do with my studies or some arguments with my friends and parents. I realize now I didn't have any serious problems. I just worried about little things. But when the war broke out, there was a curfew and everyone had to stay in their homes. You couldn't go outside. There were no lessons. All the schools were closed. While it is painful to see the direct impact of this war on human lives and livelihoods, this invasion will also produce less physical, psychological ones that could linger for generations. Such difficult experience can lead to severe consequences, including post-traumatic stress disorder, depression, and anxiety. Post-traumatic stress disorder symptoms include terrifying and realistic flashbacks of war scenes, intrusive memories of trauma, panic, inability to sleep, and nightmares. Children often remain so scared that they cannot leave their parents' sides even when they are no longer in direct danger. Researches show that especially for war trauma, many people do not recover for up to 3 years after the trauma unless adequate support and mental health care is available. The conduct of hostilities in Ukraine is being monitored by different stakeholders at the national and international level. How the massive involvement of so many actors can somehow be organized so that when the arms will be silenced, hopefully soon, justice will be done. I think that coordinated and organized effort should be undertaken to avoid duplication and make more effective the search for truth and justice. Because victims deserve justice, and the right to the truth is one of the components of the right to justice. In this regard, victims have a main interest in the establishment of the facts and the identification of the perpetrators. In the process of implementing this right through criminal proceeding at the national and international level, victims have a key interest in the outcome of proceedings, which must bring clarity in relation to what really happened and fill the gap that might persist between procedural findings and the truth itself. victims have a right to contribute to the search and the establishment of the truth. A process which entails the speaking out, the sharing of events happened to them, the recognition of the harm suffered, as well as the crimes that generated said prejudice. This process must allow victims to convey their experience and knowledge of the events. And finally, it's also a question for victims to advance the facts so that reconciliation can be achieved somehow through the punishment of the persons responsible for the crimes committed, that justice is done, and hoping that the courage of victims telling their stories and looking for justice will set an example to prevent the commissions of crimes of concerns of international community.
Thank you, Paolina, for highlighting the individual stories and especially for mentioning the psychological impact on victims and children. Many of the victims are indeed children. Let's proceed with our second speaker. Dmytro, I pass the floor to you.
Thank you, Rastislav. Good afternoon, everyone. First of all, I would like to thank the organizer for inviting me to speak at this event on such an important topic. During my intervention, I will briefly address two topics. First, I will address the role of the victims in investigations pertaining to the most serious international crimes and the importance of the active involvement of the victims of the war in Ukraine in investigations and judicial proceedings. And second, I will speak about the importance for all stakeholders to exercise particular caution when dealing with the victims in order to avoid or at least mitigate risks of the victims' re-traumatization. First of all, it should be recalled that when investigating and prosecuting the most serious international crimes are concerned, the purpose of justice-making mechanism is not only to bring perpetrators to justice, but also to ensure the right of victims to truth and justice. In other words, the purpose of such justice-making mechanism should not only be retributive, but also restorative. In this regard, Article 68, paragraph 3 of the Rome Statute provides for the right of victims to participate in the ICC proceedings in any stage. The ICC jurisprudence reinforces this provision by emphasizing that victims play a central role in proceeding before the ICC, and their participation should be effective and meaningful, not purely symbolic. One of the integral components of the victim's rights to truth and justice is the right to effectively contribute to the search for the truth. As regards more specifically the situation in Ukraine, the victims of the war can currently contribute to investigations carried out by the ICC prosecutor, basically in two ways. Some victims may already be approached by the ICC investigators for the purpose of their eventual involvement as witnesses in future judicial proceedings. Or otherwise, any victim, like any other person, can transmit to the prosecutor relevant information and evidence in his or her possession on crimes committed, and in addition, information about his or her own experience and harm he or she suffered as a result of the commission of the crimes. This way of the victim's involvement is important not only because it's likely to help the ICC office of the prosecutor better focus its investigations and appreciate the extent of victimization, but also because this is a way for the victims to realize another important component of their right to truth and justice, which is the right to be listened and to be heard. The issue here is that as of today, already tens of thousands of communications have already been sent to the ICC office of the prosecutor regarding the situation in Ukraine. Although it's currently impossible to assess the relevance of the information provided due to its confidentiality, but it is unlikely that these communications are systematized or coordinated. Therefore, for the very practical or pragmatic reasons, it is highly desirable that the transmission of relevant information on behalf of the victims to the ICC office of the prosecutor be preceded by its systematization with help of experienced lawyers, and preferably in a coordinated manner to prevent duplications. It should also be emphasized that the victims of the most serious international crimes shall have right to effectively participate in any truth-seeking and justice-making mechanism, not only before the ICC, but also at national level. Indeed, the provisions of the Rome Statutes are not exclusively rules for the internal use of the ICC, but also define the parameters of and model of the restorative justice making, where the victims of the most serious international crimes can realize their right to truth and justice at either international or national level, and regardless of whether or not the respective state has ratified the Rome Statute. In this regard, in relation to the situation of Ukraine, the primary responsibility to investigate and to prosecute the alleged war crimes and crimes against humanity lies with the Ukrainian national authorities. The very first trial against the perpetrator of the war crime of murder has just been completed in Ukraine. It seems that in that trial, the role of indirect victims of said crime was limited to giving testimony only. It is unclear how, to which extent the victims were otherwise involved in national investigations and proceedings, but it seems that the national legislation has not yet been harmonized with norms of the international humanitarian and international criminal law. Thus, there is no specific provisions in the Ukrainian legislation on handling cases pertaining to the most serious international crimes, and accordingly, there is no specific provisions governing the participation of victims of these crimes in other investigations or judicial proceedings. Therefore, it seems there is a need, as a matter of priority, to adjust the national legislation in a way to enable the victims of the most serious international crimes to effectively realize their right to truth and justice at national level. For instance, based on the model provided by the Rome Statute, as developed by the SEC jurisprudence, regardless of the fact that Ukraine has yet not ratified the Rome Statute. This is crucial, given that the majority of all proceedings against perpetrators of the most serious international crimes in Ukraine are expected to be held in that country over the years to come. It should also be emphasized that the victims' active involvement in investigations and judicial proceedings is crucial not only for the interest of justice, but also for the victims themselves. It is well known that there can be no lasting peace without justice. When it comes to the most serious international crimes, the victim's path to lasting peace is usually difficult and long. This path begins with understanding and realizing what has happened to them, and includes finding ways to establish the truth and achieve justice, participation in proceedings, bringing perpetrators to justice, reparation of harm, and often reconciliation with other members of the community. The inability to benefit from any of these components significantly complicates the path to rehabilitation and ultimately sustainable peace at the individual, family, and community levels. Accordingly, the active involvement of the victims of the war in Ukraine in the procedures of investigations and future judicial proceedings is not only a key requirement for the realization of the rights of truth and justice, but also an important element in the beginning of their rehabilitation. This means that such involvement should not be limited to providing information as testimony as witnesses, but should also include the opportunity for victims to provide information about their own experiences and the harm they have suffered as a result of the crimes committed against them. This is a key element in the right to be listened and to be heard. The Rome Statute not only provides for the right of victims to actively participate in the ICC proceedings, but also imposes on the court the obligation to ensure the victim's safety, security, dignity, and well-being. This obligation extends to all stakeholders involved with victims. The specificity of the situation in Ukraine is that active national and international investigations have already begun when the armed conflict is still ongoing. The instances of the victimization in Ukraine are very recent, and many victims are traumatized to various extent or otherwise extremely vulnerable. But the victimization of even those victims who managed to flee the war and are currently located in safe areas outside Ukraine, it still continues, because in the circumstances of the ongoing conflict, they continuously experiencing stress, emotional, psychological pressure, not only because they are far away from their homes, and simply because they worry about their relatives and friends who remain in Ukraine. They worry about their homes and generally about their future. Given the large number of the victims, it can be anticipated that only a limited number of them have received so far comprehensive psychological assistance and support. And consequently, any interaction with the victims of the war in Ukraine had the potential to lead to their re-traumatization. And thus, a particular caution should be exercised by all stakeholders involved. In particular, in relation to investigations since the beginning of the war in Ukraine, several investigative, truth-seeking, and fact-finding activities have been triggered. But it can be anticipated that because of particular mandated valuable resources of each stakeholders, not all of these different stakeholders will have sufficient experience, expertise, and necessary tools to properly deal with the victims of the war in Ukraine. To emphasize again, most of them are traumatized or otherwise extremely vulnerable. In particular, while the ICC Office of the Prosecutor obviously has experience, expertise, and necessary tools to properly deal with the victims during its investigations, it is unlikely that the other stakeholders will be equally equipped. For instance, it seems that the Ukrainian authorities are still in process of developing corresponding protocols on dealing with victims, and in particular, for now, don't have experience or expertise to deal with the most vulnerable categories of victims, such as Hgbv victims or victims of torture or inhuman or degrading treatment. In relation to the process of collecting and documenting information and evidence from the victims of the war in Ukraine, because these victims are traumatized and otherwise extremely vulnerable, this obviously requires the involvement of lawyers with experience in assisting victims of most serious international crimes, and preferably psychologists, to avoid or at least mitigate risk of re-traumatization. But the adherence to the do no harm principle is also expected from other stakeholders, in particular journalists, when interacting with the victims of the war in Ukraine for the purpose of their independent investigations, and all Ukrainian national authorities when making public statements on particular instances of victimization. On this topic, I have recently noted with concern the use of frivolous or inappropriate language in some of the publications and authority statements when reporting in particular on Hgbv crimes. These publications and statements also included details which may lead to the identification of the victims, with entailing risk of the victims' re-traumatization and or stigmatization. Again, to emphasize in this regard that protection, or at least caring about the victim's safety, security, dignity, and well-being is a common responsibility of all the stakeholders, in particular in the circumstances of this still ongoing armed conflict. I will stop here and I will be happy to answer any question. Thank you very much for your attention.
Thank you very much, Dmytro, for highlighting key role the victims play in their own statute system and for emphasizing the primary responsibility for prosecuting international crimes, which lies with the national jurisdictions. That takes me to our final intervention by Neistat on the role of national jurisdiction based on the universal jurisdiction principle in bringing justice to victims in the situation of Ukraine. Anya, I pass the floor to you.
Thank you very much. And like others, thank you very much for organizing this important discussion. And I'm actually very, very glad that Paolina and Dmytro opened this conversation by putting the emphasis on the victims, because I think in this current rush to accountability, I am very concerned that the victims will be forgotten and denied the dignity, the rights, and the agency on which the success of this accountability project ultimately lies. And I'm very, very glad that they emphasized both the situation and the massive victimization of the civilian population in Ukraine, but also all the challenges and concerns that need to be taken into consideration as we try to deal with this crisis, with this war, which is frankly quite unprecedented. And let me start probably there. I do think it's important to acknowledge that what we're seeing right now in Ukraine hasn't happened very often in the 21st century. And of course, there are many parallels to be made, including with other aggressive actions by the Russian Federation. But when we're talking about an open aggression under international law by one country against another, it actually isn't happening very much these days. Mostly we're dealing with internal conflict, often with the participation of external forces, but not such a blatant violation of international humanitarian law. And another reason why I think the situation that we are dealing with is unique is the drive toward accountability that happened from the first days of the conflict and is unrolling as we speak. Again, I have worked in most of the wars and conflicts that happened over the last more than 2 decades. And I don't think the world has ever seen anything like that. You already mentioned, I don't need to repeat all the different initiatives, including the ICC investigation, which was opened from essentially the first weeks of the war. And yes, we can remember that the case was sitting with ICC for a while before, but nonetheless, the official investigation did start, and the effort being put by the ICC into this investigation is also quite unprecedented, partially because it's one of the rare situations where ICC investigators themselves, ICC teams of experts, have access on the ground. This is really not the case in most of the other cases that ICC is currently investigating. And the same can be said for the UN Commission of Inquiry, the OSCE monitoring investigative mechanism, Moscow mechanism, monitoring mechanism, I suppose it's called, and all the other efforts by, of course, the Ukrainian authorities at the first place, but also by the national authorities in other countries, right? We're seeing already France sending investigators to assist Ukraine. And I do think that in some ways, it creates significant challenges and significant opportunities. So let me just say a little bit about both to kind of expand this discussion a little bit, focus and maybe add a few words about specifically the universal jurisdiction proceedings, which again, we're seeing an unprecedented number of investigations open just in the first months of the war, compared to all of the investigations that have been opened in the last 20 years into every other situation that I'm aware of. So I think it is, for me, it is absolutely an absolutely unique, pivotal moment for international justice more broadly. And let's all, acknowledge and say what, I think most of the people who work in this field are thinking about, that, Ukraine, of course, presents a very difficult question to everybody in terms of any other situation in which civilians are suffering similar harm, be it Syria or Yemen or Sri Lanka or Ethiopia, and the list goes on and on. Why hasn't the world in general responded the same way? And we can, I think there's a lot to think about there and a lot to reflect on. In terms of how we as an international community treat different situations. But I think there is also a different way of looking at it and making sure that from now on, that type of response, and hopefully, that would lead to some impactful results, this type of response becomes the norm. And, I think this is up to all of us, the lawyers, the activists, the journalists, and the communities themselves, to ensure that this is how it is going to be, what is going to be the standard, be it the effort put by the ICC. And yes, it is a unique situation and it wouldn't be applicable in every conflict, but it does show what can be possible. Or of course, the investigation put together with enormous international support by the national authorities, or the national investigations that are being launched in jurisdictions outside of Ukraine. I think if we get it right this time, there will be less of an excuse to not get it right the next time something like this happens. And unfortunately, I'm both an optimist, but also a realist. And I do think it's not, unfortunately, the first war that we're living through in the 21st century. And I think there are lots of lessons that we can start learning right away. And some of them have been highlighted by both Paolina and Dmytro in terms of what it means for victim participation, for protection of their rights, for ensuring their protection in the proceedings, for frankly explaining what all of this means to them. This is one of the challenges that I'd like to come back to briefly, but also in terms of how all of that needs to be or can be coordinated. And that's where I'm switching a little bit more to the challenges part of it, because again, what we're seeing is a fairly unprecedented activity by not just the official mechanisms, but also NGOs. I take part in NGO coordinating meetings where we have, 50 different NGOs or 50 different participants, all talking about different efforts that they're putting in place for documentation. And to a certain extent, accountability. And I think that creates, very interesting opportunities, but also significant challenges when it comes to duplication, both of efforts and resources, but also, of course, of the way the witnesses and victims are approached. And, this image of 15 different organizations running after the same witness. I think there is already a caricature in Ukrainian that reflects that out online is extremely dangerous, and it's dangerous because of re-traumatization, about traumatization, re-traumatization, about which Dmytro spoke, but it's also very counterproductive for any justice processes that accreditation of witnesses and survivors in the proceedings to come. And I think that also relates to how do all these mechanisms of justice will actually work. I think there is a way of making sure that all of them deliver what they're supposed to deliver, and that's where I think UJ proceedings come into play. The primacy would, of course, lie with the Ukrainian prosecutors. ICC would obviously focus on the top perpetrators. They would be able to bring to justice, a handful, and then I think there are multiple opportunities for the survivors to pursue justice outside of Ukraine. And that could be for various reasons, because they are already in jurisdictions where they could make claims, and that depends, of course, on the jurisdiction, or because for whatever reasons, and I'm already hearing this from some of the survivors of sexual violence, for example, they would not want to proceed domestically, either because they do not have sufficient trust in the Ukrainian system, or because they want the level of anonymity that proceeding with their case elsewhere might provide. There are obviously situations of foreign nationals. In France, for example, there are already 5 cases open into French nationals. And this also opens a possibility for Ukrainian survivors to be added to those cases and probably pursue a faster, potentially faster road to justice. I also think that it is very important, and one of the things we are trying to do at the Clooney Foundation, at the Docket program, is to make sure that we expand the investigations launched by national jurisdictions beyond Western Europe and Canada, where they're currently, and Eastern Europe, where they're currently being launched, and actually use the allegedly 169 countries that have these universal jurisdiction mechanisms to pursue both the symbolic condemnation and the actual justice proceedings. And that will be important both symbolically and also in practical terms, because I strongly suspect that when the perpetrators start running, they will not be running to Eastern and Western Europe. They will be running to Latin America and Asia and some Middle Eastern countries, where they would assume they have more protection from prosecution and where their assets largely are. And I think launching proceedings and pushing the systems, the law enforcement systems of those countries to pursue such cases would be a very interesting strategy, which would both expand the possibilities for justice for the victims, but also expand the possibilities of bringing the perpetrators to account. I'll stop here, and we'll be very glad to answer any questions as they come.
Thank you very much, Anya. I very much liked your remark about the pivotal moment for international justice. And thank you for highlighting positive response of the international community, but also the advantages and challenges in investigating these crimes. We have a couple of questions in the Q&A box, so I'll proceed directly with them. The first question is probably addressed to all 3 of our speakers, so I will quote it. How has social media, digital technologies impacted the victim-centered approach? Has it empowered the victims to take leading roles in their own cases, or does it negatively impact proceedings by causing unrealistic expectations? Now let's proceed with the initial order of speakers. So I will start with Paolina, please.
Well, I think that, again, as Anya was saying, is we are assisting to something really unprecedented in a lot of fields and areas, and certainly the digital possibilities are much more evident in this world than in others. And I would say that people are very aware on how to use these digital possibilities that they have. Instagram is full of stories. You can see videos of what is happening live in a specific area. People are constantly connected despite the difficulties in internet. Now, I would not say that this has an impact in empowering or not empowering victims at the moment, because for me, the process of empowering goes through the process of truth and justice. But I would say that it's certainly helpful in collecting information and potential material which could become evidence. And it's certainly also an impact on how people may react to what is happening, and in creating a movement around this war, which again is certainly unprecedented. So I will not speak about empowerment, but I will speak more about possibilities open to victims of recording live what happened to them, and in generating support and possibilities for potential evidence.
Thank you, Paolina. I pass the floor now to Dmytro for his remarks.
Yes, thank you. I agree with Paolina that it's not the question of whether to empower the victim, because the question is mostly whether in which particular system victims, and to which extent victims can contribute to the search for the truth. Because as we know, under the Rome Statute, the victims have quite substantive, extensive rights to participate in proceedings and to contribute to the search for the truth. Of course, it depends on specific cases. Sometimes victims have more rights in one case, in another case, less rights. But this still, as I mentioned during my intervention, this is a model which should be used not only at the ICC, but also at national level. And because, as I also mentioned, that it can be anticipated that most proceedings in relation to the pertaining to crime committed in during the war in Ukraine are expected to be held in Ukraine. But the issue here, as I flagged already, the problem that the Ukrainian legislation does not provide actually the possibility for the victims to be actively involved. I know that the amendment to the national legislation in relation to the harmonization of the national legislation with the norms of the international humanitarian and criminal law have been pending for many years. And now, when the situation is, I would say, urgent, I guess that the national legislators should take measures as a matter of priority in order to put in place specific procedures from the victim perspective to provide the victims with the possibility to play an active role, because it's a part of their right to truth and justice.
Thank you, Dmytro. And lastly, Anya.
Yeah, well, it's a huge area. I would just say that I agree with Paolina. It is this conflict is also, the war is really unprecedented when it comes to the level of documentation, including citizen documentation. I do think there is a danger that it creates unrealistic expectations, as the question suggests, especially I think when in the first days after the opening of the ICC investigation, there was an email address where everybody can send their reports of violations committed without sufficient explanations provided. I do think that it might create unrealistic expectations. At least that's definitely the questions that we are getting from people who we interview, sort of what happens. So I submit this email and that happens. There is also a website created by the Ukrainian Prosecutor General which on one hand is a very interesting and innovative way of collecting information. On the other hand, I think there are some concerns about who and how collects the information and what will be its legal value, let alone admissibility, especially in processes outside of Ukraine. But it's also, I do think that I think it's critically important to make a distinction between kind of more classic human rights documentation, for which I think this citizen reporting is critically important, and documentation at criminal grade process for evidence that can be presented in court. And that's just a completely different, I would say, sphere, and the way, for example, we in our work interact with witnesses and victims, not taking detailed statements and making sure that, the prosecutors ultimately have the primary role in collecting their statements, but also everything when it comes to collection and verification and authentication of documents and videos, and, all of these lists of, soldiers and photographs and satellite imagery and all of these open source information and the information that is being collected by people on the ground. I think it is important to understand that most of this information will not stand in court, and does it mean that it shouldn't be collected? By all means, no. But I think it's very important to be clear, especially if we are asking people to send something somewhere, to explain how and why it will be used. And now I see already there are lots of trainings being set up on how to film videos and how to collect photographs, and I hope it will help to collect information that is usable. But ultimately, I think general engagement with survivors and witnesses in Ukraine, but also elsewhere, is absolutely critical, because at this point, I think there is very little understanding of what does ICC mean? Does it mean that I will have my day in court? What does this investigation mean? Who will be brought to account? Is it the soldier who came to my village, or is it President Putin, right? Let alone universal jurisdiction. Most people, frankly, and as I see, even in kind of professional legal community in Ukraine, have lots of questions as to why would France or Germany be involved in crimes committed in Ukraine. So I do think that for victims to be truly empowered, this is a critical piece in which, in turn, social media, I think, can play a critically important role if we get it right, and if the messaging is right and to the point.
Thank you very much to all three of our speakers, and I see that we have a couple of questions piling in the Q&A box. So I'll proceed with the second question, specifically addressed to Paolina and Dmytro, and specifically about what your office can do at this stage to support these victims. Let's take Paolina first.
Well, thank you for the question. First of all, I think it's important to say that the Office of Public Counsel for Victims has a mandate also to support and assist victims at very early stages of the proceedings before the court, not only at the investigation, but even at the preliminary examination, which means that we are already, to some extent, called by victims from Ukraine and outside, requesting advice, requesting what does it mean, very concretely, to be a victim before the ICC. Anya was saying sometimes it's very difficult when you raise expectation, and I think that we are really in that period at the moment. We have people who ask us, okay, can I bring my file to you? Thinking maybe that it will be the case of Paolina against Putin or something like that. Also, there is really a lot of misunderstanding at the moment, and we have been trying to support victims. So first of all, in explaining to them exactly what is happening at the moment. And we really think that this is needed because victims, and generally public, are bombarded by a lot of information at the moment. There are a lot of sites on which victims can send information. There is a pathway on the ICC website, which in my opinion, it's not so easy to use. So all these initiatives, which are good initiatives, people have good intention, but if we do not arrive to coordinate these good intentions, that maybe accountability will be to arrive at accountability will be a much longer process of what we would have foreseen since the beginning. So we are trying to, we are contacted directly by victims, and we are trying to explain to them what's happening. In some occasions, victims can rely on us in liaising with the prosecutor. We already did that in other situations and cases. Our main role at the moment is try to advise them and support them with legal advice if they wish. We are also in contact with different stakeholders and organizations that may be interested in finding common ways of addressing several areas of crimes, in particular sexual and gender-based crimes and crimes against children. I can go on with a lot of examples, but considering the time, I prefer to keep the answer short.
Thank you, Paolina, and I pass the floor to Dmytro for his response.
Yeah, basically, Paolina has covered the topic. I would like to just flag the fact that, as Anya also mentioned during her intervention, that there's an issue with Hgbv victims in Ukraine who most or many of them refuse to deal with the national authority because of lack of trust, lack of trust in the system, or in other issues. However, the problem that not only the Ukrainian national authority lack experience and expertise to deal with this category of victims, but also NGOs involved in the process. So this means there's an issue of where these particular category of victims can go in Ukraine, because there's either national authorities, non-NGOs, can provide them with comprehensive assistance. So in this regard, we, of course, I will not provide some details, because our interactions with respective NGOs are confidential in any case at this stage. We, in any case, try to find a way to help to the NGOs active in Ukraine in relation to different topics. Yes, and hopefully because now what we see that the Ukrainian national authorities and Ukrainian NGOs need to be provided with different sort of trainings, different sort of assistance on how to deal with vulnerable victims, how to deal with other aspects, because they are not basically ready. And on our side, of course, we try to be helpful, to provide some assistance what we can do at this point in time. But apparently, there's a lot of things to still to do, and not only on our side, but from the international experts, from the experts on trauma, psychologists, etc.
Thank you both, Paolina and Dmytro. And let's take another question. And let's start with the reverse order, starting with Anya now. Do you think trials in absentia are practical, worthwhile, or to be avoided?
Do I have 3.5 hours? No. In short, no. Meaning they are neither practical nor do they, in most cases, adhere to the fair trial standards that most of us would want to see. So without expanding and going into all sorts of legal intricacies and exceptions, I would say that what is, I think, more interesting in this context is the possibility of proceedings that would lead to arrest warrants, and issued obviously in the absence of the perpetrators in a particular country. And in many jurisdictions where, based on the passive personality principle, like in France, you can start the proceedings based on the nationality or attachment of the victim to the country. you could potentially proceed with arrest warrants. And that, I think, obviously it's not, again, I'm not trying to avoid the question. I hope I answered it briefly, but I do think that there are, because, I assume the question is there because most of the perpetrators are not currently in the jurisdictions, at least where they can be pursued under the universal jurisdiction principle. So the question is, can they be, especially the higher ups, can they be tried in absentia? And I think, and the reason I'm mentioning the arrest warrants here is because I do think that this might actually be an effective tool of essentially making the world smaller for the perpetrators, right? Does it mean that, we will catch them tomorrow? Absolutely not. But the arrest warrants, the Interpol red notices, have led to arrests of the perpetrators in other cases. And I do think that pursuing this in this context would also be useful.
Thank you very much, Anya. Let's proceed with Dmytro, please.
Just to underline that under the Rome Statute, the in absentia trials are not possible. Now, in relation to what was Anya mentioned, that the warrants of arrest could be of help, I can refer to for now it's a single instance in the practice of the ICC when the office of the prosecutor issued or requested or informed or announced the issuance of warrant of arrest against three or four suspects, and in three suspects in the situation of Georgia. This was the first time in the history of the court it was happened, because normally the warrant of arrest is made public when the people are already transferred to the court. So this was an example, but this was made based on the announcement made by the prosecutor. It was a sort of signal to Russia that everything can happen. And of course, we understand that at this point in time, these people are located not reachable, I would say, for the justice. They are either on occupied territories in Georgia or in Russia. However, since we have been following the development of the situation in Ukraine, and things can change shortly. And if today these people are not reachable for justice, maybe tomorrow they can be reachable. So I don't suggest that the office of the prosecutor of the court needs to issue warrants of arrest against some of the potential suspects in relation to the situation of Ukraine, but maybe it could be a way also to send a signal, because again, the things can rapidly change, and the possibility to get these people in custody of the court can be a reality in the future.
Thank you, Dmytro. And finally, Paolina.
Well, despite being a civil law lawyers, I would say also no. Trial in absentia, and mainly for what has been said, but I would like to put the accent a little bit more on the victims. For victims, it's important to face the person that they think is the perpetrator. It's important for the process of justice. It's important for the process of healing. It's important for being part of a process of reconstruction of what happened to them. And also it's important for victims to be able to turn the page.
Thank you. Let's take another question. It's about the latest conviction of Vadim Shishmarin, the life sentence conviction. Let's start with Anya. Do you think the trial was satisfactory in terms of delivering justice and accountability in this case?
I'm not in a position to comment on that. We were not monitoring the trial carefully. I have not seen any, at least reported glaring violations. Of course, when the trial happens so soon, these questions inevitably arise. I think my biggest question is the sentence, right? The fact that he was given life imprisonment after pleading guilty could be very problematic, because it's not entirely clear what would be the incentive for any other defendants to plead guilty going forward, because normally the idea is that the guilty plea reduces the sentence, and that creates an incentive to mainly reduce the burden on the prosecution. Of course, it's kind of a little bit more relevant for common law systems, but in the civil law systems as well. So I wonder how this sentence would affect the cases that we're about to see, of which I think the Ukrainian prosecution has many lined up.
Thank you, Anya. Dmytro.
On this trial, as I already mentioned during my intervention, I would say this was, of course, this was the very first trial in relation to the war crime of murder, and it was quite simple, I would say, for the apparently for the Ukrainian authorities to bring this perpetrator to justice. But I would say that this is symbolic trial because the first one. This is also a sort of signal for the future potential suspects. And but my concern here is that the way in which the victims of this the indirect victims of this crime participated in the proceedings, it's my understanding that their participation was very limited. Now the question is, because again we can anticipate many other proceedings in the future in Ukraine, so I would say the urgency is for now for the Ukrainian legislators to put in place, to amend, to adjust national legislation to be prepared to many other proceedings in the future.
Thank you, Dmytro. And finally, Paolina.
Yes, I mean, me too. I don't have first any information of what happened in courtroom, so it's very difficult to give a judgment on that. For what I could observe from the outside, I would raise some concern in relation to the sentence, as Anya was mentioning, in relation to the participation of victims, in relation also to the type of legislation which was applied by the National Court. The newspapers reported murder. So murder as a normal crime, as a war crime, as what? It makes a lot of difference, I think, also for the victims themselves. Again, for this issue of looking for the truth and going for that and participating meaningfully. I can understand, and also to some extent, the fact that it was very fast. It was really fast. So I would raise these kind of concerns, particularly knowing that the Ukrainian legislation, if I'm not wrong, is still not adapted to the crimes under the Rome Statute. And this is a serious concern if we really want to achieve justice for victims in Ukraine.
Thank you. And we will take a couple of more questions before we finish. And the next question is probably addressed to both Paolina and Dmytro. And it's about the possibility to consider submissions of the applicants which were previously considered by national courts or by other international institutions, such as the European Court of Human Rights. Paolina, please.
Not sure I fully understand the question. I can see two possible options. The first one is Stanislav is in relation to potential victims before the court, if is what applicants means in his mind. Now, if the question is, can application brought before the European Court of Human Rights, Commission of Human Rights or whatever, be brought directly before the ICC? The answer is no, because the ICC has a specific procedure for participation of victims. If the question is, can individuals who already brought application before other court be allowed or recognized as victims before the ICC? The answer is yes, as long as these individuals will comply with the criteria under Rule 85 of the Rules of Procedure and Evidence in relation to the charges eventually brought before the ICC against a specific perpetrators or perpetrators. I hope it's clear. If not, Stanislav, please send an email and we'll engage more deeply in the conversation.
Thank you, Paolina, and let's take Dmytro.
Yes, the answer to this question that yes, because of the different jurisdiction or jurisdiction of all these bodies quoted by the participant, in principle, there is no impediment for instance, some submissions made before the European Court of Human Rights about the violations suffered by a particular person to bring this information before the International Criminal Court. There is no problem with this. The question is that at this point in time, there is no possibility for the victims to be admitted to participate in the proceeding because there is no proceedings yet. However, as a matter of possibility to transmit the relevant information to the office of the ICC office of the prosecutor, this possibility exists. And you can bring this information to the office of the prosecutor. But again, the question is, as mentioned by all the speakers, that it's very desirable that the information provided to the office, ICC office of the prosecutor, is systematized, coordinated, and structured in a way that this information could be processed by the office of the prosecutor swiftly and effectively.
Thank you, Dmytro. And we will take one final question, and I ask all three of our speakers to answer it very briefly. And it's about your insights about possible charges for genocide in Ukraine. Let's start in the reverse order by Anya, please.
Briefly, well, as you know, there is an ongoing discussion about whether the crime of genocide will ultimately be part of the charges. So my short answer is we don't know. If you want my legal assessment, I think that so far, from everything we know, I think it would be difficult to go with this crime in court. But as we know, unfortunately, the conflict is ongoing, and we just do not have the full range of evidence to make this conclusion. There are definitely lots of reasons from what we're seeing on the ground to consider that possibility. And I think most lawyers out there will continue to consider it until it is ruled out. I would just say one more word, which I think is very important, and one of the cases that I really hope will happen is the incitement of genocide, which is a very different offense. And interestingly enough, to prove the incitement to genocide, you do not need to establish that genocide is actually taking place. But for me, what is happening in the Russian media and by the Russian propaganda figures is such a huge part of what's happening on the ground that I do hope that some of the best legal minds out there do work on that, because this is, I think, difficult. There haven't been many cases like that in history, but so critically important as part of both the narrative and the actual charges that I would really like to see.
Thank you, Anya. Let's take Dmytro's turn on possible genocide charges.
Well, this question, I got this question because sometimes ago I was requested to make a comment in media about whether there is a crime of genocide committed in Ukraine. I specifically declined this because I think it's a bit premature. And I know that there is a huge interest in Ukraine. In any case, almost everyone speaks about the genocide committed against Ukraine. It could be the case, but I would say that at this point in time, it's premature, and it will be to the relevant authorities, either the ICC prosecutor or Ukrainian authorities or any other national authorities to determine on this matter. So I would prefer not to go through in depth on this matter for now.
Thank you, Dmytro. And finally, Paolina, if you'd like to add.
I think it's really unlikely at the moment, for different reports that I've seen, for what we see daily, to go for that charge. It's very, very difficult to prove. I totally agree with Anya. I was also go for incitement to genocide. There are a lot of new reports from different sources on propaganda and the use of media, which to some extent take a little bit further the concept which was developed in the media trial before the ICTR in different ways. So I think this is certainly a path that jurists should consider. But going for genocide at the moment, it seems to me premature and very difficult at the moment to prove, even to find reliable evidence credible in courtroom. But unfortunately, it's a war still ongoing.
Thank you, Paolina. And as our time is slowly running out, I would like to thank all three of our speakers for giving great interventions and the public for joining us for this important debate. We have heard about so many important initiatives in the global effort to bring accountability for crimes in Ukraine. And I'm also happy to share on this occasion that our organization is joining an international initiative called Project Sunflowers, collecting information from Ukrainian refugees in Europe, prospective victims, and the information is possibly to be used in criminal proceedings. There is one more webinar scheduled in this series, so please stay tuned for the announcement. Thank you again for joining us and have a nice evening, everyone. Goodbye.
Goodbye, thank you.
Thank you again.